Good afternoon, ladies and gentlemen. My name is Carl Atkinson, and I'm a partner in the gunnercooke Employment and Pensions team. This webinar is part of the People Hour Employment Update series, and I'm grateful for your attendance this afternoon. The software that we are using for the purpose of this webinar will allow you the opportunity to ask me questions as I'm going through the presentation, so that's great. Please use that facility. And what I'll do is, if I think that I can deal with a question easily during the course of the presentation, I say easily, reasonably within the course of the presentation, I'll do that. If it's something that's better left to the end of the presentation, I'll leave it till the end. And if it's something that's going to require a bit of thought or lateral thinking on my part, what I'll do is I'll take the question away and email a response back to you. So if you do have any questions, they will be addressed either pretty quickly or after a bit of thought. I'm also told that we will be emailing out a recording of this presentation to the people that signed up to attend. So if you're not able to keep up with your notes, or I say something that you're not sure you noted correctly, you will be getting that recording in due course. So thanks for attending, and what I'd like to do is move on to the first slide. And what I wanted to do in the presentation today was recap some recent developments which have occurred in relation to the law on disability discrimination. And what I wanted to do was look back slightly and then try to look forward a little bit as well and speculate on how things may develop over the next 12 to 24 months. So I'm doing that, and I picked this particular subject because I think we've all practitioners have witnessed a growth in disability discrimination claims and complaints. And unlike a subject like sex discrimination, which has been an area of law in development since the 1970s, disability discrimination is a more contemporary concept. The relevant legislation has obviously developed from the Disability Discrimination Act, latterly through to the Equality Act, and what we've seen over the past few years is that the legislation has been fleshed out in a good number of significant legal cases. So, in my view, what we're seeing over the quite recent history is an expansion of the law in relation to disability discrimination. And I think in those circumstances it merits close analysis. So I've picked 4 key areas of recent developments in relation to disability discrimination, and I've set these out on this particular slide. So I'll be running through these because I think that they are key areas of law if you're dealing with issues of disability discrimination. Certainly the question of who is disabled is something that seems to crop up time and again in my practice when I'm dealing with these type of claims. And the other thing, which is a huge feature and I think a growing feature of disability discrimination litigation, is the concept of reasonable adjustments and allegations of a failure to provide reasonable adjustments, particularly for people who are working in a large employer type environment and especially actually the public sector. So I'm going to be looking at some of these cases and some of the developments in these areas in detail, and then hopefully trying to project forward a few thoughts on how we might see these areas develop over the immediate future. So, in relation to this question of definition of disability, this is a very important concept because it underpins all of the obligations that arise from the relevant legislation. I think that all practitioners analyse legal questions in many different ways, but in the same way that when I get asked by clients, can they take a particular course of action against a particular employee, the first thing that I always think about is what the contract says they're entitled to do. And with disability claims, the first thing I always think about is whether or not the complainant is disabled. I think also that it can be tempting sometimes to gloss over that analysis just in the sort of run-of-the-mill of everyday commercial life and the mud and bullets of HR practice on the front line. But it's a relevant consideration in disability claims because if the claimant or complainant is not disabled, then all of the obligations under the legislation don't apply. So essentially what happens is that the claim never gets off the ground or the complaint never gets off the ground. One of the things that does strike me as interesting, though, is that I'd really like to see some accurate metrics for the UK economy, analysing the percentage of the workforce who now qualify as disabled for the purpose of the Equality Act. I did some work fairly recently for a large public sector organisation, government department, which employed a significant number of people, often in a call centre type environment or large offices located in disadvantaged areas throughout the UK. Those type of roles were largely sedentary roles in a white-collar environment with some flexibility about working patterns, and this tended to attract applicants from a similar social demographic. And it was quite clear from the research that that client had done that they were at a situation with those offices and those locations where the majority of their workforce would fall within the Equality Act definition of being disabled. So I think for employers who are in that situation, and it may be that that's where many employers are going to get to over the next few years, I think that it's worth considering drafting HR policies on the assumption that they will always be applied, or will be applied in the vast majority of cases, to individuals who are disabled for the purpose of the legislation. I think perhaps a more cynical person than me could be tempted to speculate that one of the outputs from the legislation and the quote benefits unquote that are provided to disabled people under the legislation may be to encourage more and more employees to regard themselves as being disabled and to attempt to seek that status for the purpose of the legislation. So I don't know actually whether we're going to see an increase in the statistics relating to the number of disabled people in the workforce, but it wouldn't surprise me if that happened. So that's something that might be worth bearing in mind. In respect of this issue of definition of disability, this is a legal test and not a medical test. I very often find that clients don't have a firm grasp of that point and will come to me and we get into a discussion about whether or not a particular employee is disabled, and the client will have in their mind quite a preoccupation with medical evidence. But in fact, that's not the correct test for the purpose of any litigation. The people that will decide whether an employee is disabled for the purpose of the disability discrimination claim will be the members of a tribunal if any litigation progresses to that point. It doesn't really matter what view any medical expert takes, although the tribunal members should take into account relevant medical evidence. So if you are presented with an occupational health report which suggests that a particular individual is or isn't disabled, I'm not sure that that is a definitive position for you, and my advice would be to be cautious about that. But I'll go on later in the presentation to talk about a couple of cases that deal with occupational health and implied knowledge on the part of employers. So the other point I'd make actually in passing about occupational health reports is that I see these quite often that have been obtained by, usually it's my client, the respondent, and it always strikes me as being quite surprising, given what I've just said about the test of the definition of disability being a legal test. It surprises me when I see occupational health reports which offer a definitive conclusion one way or another about whether or not the employee is disabled. And I think if you do see that, and you see that regularly from a particular firm or a particular occupational health consultant, I think you might want to just reflect upon the accuracy of the information that you're getting, given this issue about the legal definition, and you might want to give that some further thought. The other point that I wanted to emphasize in relation to this definition of disability point is that conditions which are classed as a disability can be conditions which are not obvious, hidden conditions. A classic example of this is, of course, dyslexia, which may not be manifest to you during the recruitment process, particularly if you're recruiting for example, an operative type role where you might not be undertaking a written examination with the applicants. So it's worth reflecting on that if you're designing any training within your organisation, to make sure that that's communicated to relevant managers throughout the business, because I think sometimes that point gets lost as well. I'm going to talk slightly later about a case involving a claimant in Denmark called Carsten Kaltoft, but one of the particular ironies about Mr. Kaltoft's case was that his claim was all about whether obesity could be regarded as being a disability. And interestingly, throughout the legal process that Mr. Kaltoft was involved in, although it would have favoured him to be regarded as being disabled, and that was the way that his case was put, he was quite consistent in all of his press interviews in saying that he did not regard himself as being disabled because he was obese. And interestingly, that wasn't really the view that the European Court ended up taking. So perhaps inevitably there was an interesting contrast of views there. But moving on to the next slide, so moving on to this next slide, I wanted to talk about a situation which can arise where the employee or claimant suffered from a temporary incapacity. And I also wanted to talk about a Danish case called Ring versus Dansk. Sadly, quite a few of the cases that I'm going to talk about this afternoon are European cases, and my lack of linguistic ability is going to be grossly exposed here. It's like whenever I do a presentation about TUPE cases, The only case that I can pronounce with any confidence is the Daddy's Dance Hall case, and that's only because they used an English name for the respondent business rather than the German, or I think it's a German, it was in Germany, rather than the German name of the business. So I'm probably going to struggle and fail sadly all the way through the pronunciation in many of these cases, but they are written down and they will be in the notes, and I'm sure you can find them. So this Danish case of Ring and Dansk was interesting because the European Court, in making their decision, referred to the fact that the European Union has been a signatory to the UN Convention on the Rights of Persons with Disabilities. And the European Court emphasised in this particular case that member states should seek to interpret their national legislation so that it aligned with the provisions of the UN Convention. And I think that certainly I've never come across anybody suggesting in the course of any disability discrimination claims that we should be looking to interpret legislation so that it aligned with the UN Convention. But I think that that's going to be something which is going to be raised more frequently as this whole issue of how our legal system aligns with European obligations remains under the microscope and possibly becomes even more significant if we get drawn into difficult conversations about exiting Europe. So I think it's worth just mentioning, while this point has been raised, that the UN Convention discusses the issue of disability and suggests that this is not something which is what is described as an absolute concept in relation to work. So, for example, under the UN Convention, it's regarded as being perfectly possible that a disabled person would be capable of some work, but might not be capable of work to the level or standard that other non-disabled employees might routinely undertake. And of course that really then raises the question of reasonable adjustments, which we'll come on to talk about briefly in a few minutes. So I think the impact of this Ring and Dansk case will be, and both of there were two claimants in the Ring and Dansk case, and it was both of them had an issue about working hours. And the question was whether it would be reasonable for them to work reduced hours as opposed to a full-time working commitment. So that's the context of these comments about disability. And I think the impact of this decision will be to encourage courts to focus on this question of reasonable adjustments. So I don't think it's a particular secret to say that reasonable adjustments is really the growth area in disability discrimination litigation, something that I think we're all seeing many more claims in that field. And I think it will continue to be a popular area for litigation going forward. The other case that I wanted to consider at this point was the case which I assume is pronounced Diode versus Boots. And this concerned a discrimination claim which was pursued by a kitchen porter who slipped and fell at work in a restaurant in Barcelona. And what was interesting about that case was that the claimant had, I think it was an elbow injury, which had an uncertain prognosis, and it was unclear at the time of the court hearing, which I think unbelievably was 6 months after the injury. I can't believe you'd ever get a case to court as quickly as that in the UK. They had a situation where the prognosis was uncertain, and if you consider that most people will be familiar with the suggestion that under UK law there is a requirement that a disability, that in order for a person to be regarded as being disabled, they should have suffered a substantial and long-term negative impact upon their ability to undertake normal day-to-day activities. Now, this concept of a substantial long-term negative impact is actually taken from European law, the Equal Treatment Directive, but when it was brought into English law, there's been a gloss or some helpful additional information attached to it within UK law, which is that this question of a long-term impact is defined as being a condition which has lasted more than 12 months or could last for more than 12 months. So clients very often get into a situation where this issue of how long the condition has been ongoing for, or how long is it likely to last, becomes quite a significant consideration. But in this case involving the porter in Barcelona, at the point where the court was considering the case, it wasn't clear how long his condition was likely to last. So he has an uncertain prognosis, and the question was whether or not he would be disabled for the purpose of the legislation. Obviously, what had happened was that the moment that he wasn't able to carry on working, he was sacked, and he was therefore claiming that he had been dismissed as a consequence of his disability and that he was entitled to claim for compensation for discrimination. So this issue of whether or not he was disabled was critical to his case. And the interesting point in the judgment is that the European Court judgment suggested that an intermittent injury could be regarded as a disability for the purpose of the relevant legislation if the detriment which was caused by the injury would have a long-term impact. So where that takes us logically is to a conclusion that if an employee suffers from a condition which is intermittent, comes and goes over a period of time, what the tribunal will do in assessing whether that person is disabled is look at the facts of that person's particular case and the way that they live their life and the way that their condition impacts upon their ability to undertake day-to-day activities, and we'll look at whether that impact is long-term. And some of the issues that I've seen flow out of that, particularly actually with stress cases, is that you can find yourself in a situation where you're dealing with a claimant or an employee who suffers from often a stress condition, which may have meant that they have had more than one episode of absence from work over a period of time. And you then find that you're in a situation of trying to establish whether all of those episodes of absence can be in some way aggregated together in order to establish this pattern of long-term impact, or whether in fact they're discrete and isolated incidents. And that's quite a difficult situation to be in, and there's no simple answer to that other than you've got to look at the facts of each individual case, and that's where good quality medical expert evidence can be extremely helpful in order to try to work out whether this is one underlying condition which has waxed and waned in relation to the level of severity, or whether it's a number of isolated and discrete episodes. So that's probably something that's going to be a feature for many practitioners over coming years as well. There's no sign of any reduction in the level of stress-based litigation in the workplace. I also wanted to, just moving on, to talk about another case that I'd identified as being a an interesting recent development is this case of Taylor and Ladbrokes betting, which considers whether type 2 diabetes would qualify as being a disability for the purpose of the Equality Act. My understanding, I'm not an expert on diabetes, but my understanding is that type 2 diabetes is the less significant condition, and it is one which can develop into or escalate into type 1 diabetes, which is a much more serious proposition. So this case is relevant because it really develops on the theme of the intermittent illness that I mentioned previously. The claimant in this case suffered from type 2 diabetes and brought a discrimination claim which he took to the tribunal. And at the first level, the employment tribunal, his claim was unsuccessful because the tribunal held that he was not disabled, and in forming that view, the tribunal considered the day-to-day impact upon him of his condition and had in mind the fact that he was controlling it using the relevant medication. The tribunal reached a possibly surprising decision that the condition didn't have a significant impact upon Mr. Taylor. Perhaps unsurprisingly, he appealed, and the Employment Appeal Tribunal took a different view. And the view that was held in the Employment Appeal Tribunal was that it was not correct to say that type 2 diabetes could not be a disability. What the EAT suggested was that it was a condition which was capable of being a disability if there was a significant risk that the condition could worsen. So really where that judgment takes us is to considering whether employees who have those kind of intermittent conditions have the possibility, or there is a prospect that the condition may deteriorate or hopefully improve. And I think what you will need to do is look very closely at the facts of each individual case. And it's quite unusual for me to advise clients and say you've got to treat people individually. Generally, I'm a huge advocate of treating employees as similarly as possible on the basis that it reduces the risk that any employee will be able to say that they or someone else has been unfairly benefited or that they've suffered a detriment. But I think in these type of cases, you really need to look at the detail and facts of each particular case and try to understand how the condition is likely to develop. Moving on to the next slide, relating to a gentleman who's got a completely unpronounceable name. And you might want to check this name actually, because I'm not sure I put enough C's and Z's in it. There are probably many more. But this is a claim that was brought in the Employment Tribunal in the UK. And what's helpful about this decision is that it provides us with an indication of the way that a tribunal may regard the definition of normal day-to-day activities. Remember that the law I mentioned earlier provides that the definition of disability is dependent upon a substantial negative impact on the claimant's ability to carry out normal day-to-day activities. Well, this was a gentleman that worked as a picker in a distribution centre, and in that role he was regularly required to lift and load boxes containing loads up to 25 kilograms onto a pallet truck by hand. Unfortunately for him, he was involved in a car accident which caused an injury to his back, resulted in him being unable to achieve his target picking speed. I'm not really sure how that target picking speed had been calculated by the respondent, but there was one and he didn't achieve it, and he didn't achieve it over a reasonably lengthy period. And in view of the occupational health expert retained by the respondent, there was no prospect that he would be able to achieve the target in the foreseeable future. Unsurprisingly, he was dismissed, and at his first tribunal hearing, he was held not to be disabled because he could undertake lots of what were regarded as routine household tasks without any significant adverse impact due to his back condition. But on appeal to the EAT, it was accepted that the requirement to lift objects weighing up to 25 kilograms was a normal day-to-day activity for that particular claimant because it was a routine part of his usual employment. And it was also accepted that the effect of his injury was to slow him down in his ability to undertake this task, and therefore the adverse impact of the condition was substantial. And so I think in view of that decision, what we have to conclude is that an individual's ability to carry out normal day-to-day activities, which is the relevant test, may not be decided purely by reference to activities outside work. And that will especially be the case where individuals' activities at work are carried out by a large number of employees across different occupations. So I think what that means, the conclusion that we have to draw from that, is that this test of a substantial adverse impact must involve the claimant's ability to do their job. And one of the things that causes me concern about this, and that I come across quite often, is a situation where an employee is absent from work, and this may be because of self-diagnosis or self-certification or something like that. And when they present themselves to a medical practitioner, the medical practitioner factors this concept into their analysis and says, well, if this person is unable to do their job because of whatever is the relevant illness, that must be a substantial adverse impact upon their day-to-day life because they can't do their job. So it almost becomes a way of arguably creating your own disability. And I think that if you face that kind of scenario, it's something that you will have to challenge quite robustly, and that may very well be a case where you want to get some specific medical evidence based upon an examination of the claimant rather than just looking at GP notes. So then that's another point in relation to this question of disability and definition. The next point is one that I've already alluded to earlier, relating to Carsten Kaltoft. This was a Danish claim pursued by Mr. Kaltoft, who was employed by a Danish municipality, Billund, I think, as a baby minder. Many of you who may be familiar with the way that Denmark approaches equality rights may know that the provisions that are put in place there for parental support are probably world leading. I know I was reading a novel or a book recently called A Year of Living Danishly, and I was amazed at the level of support that was put in place by the Danish state for families. But one of these is there's a high level of child education support nurseries, etc., from a very young age in order to encourage mothers to go back into work. And Mr. Kaltoff was employed as a baby minder. And the evidence was that he was heavy. Some of the reports describe him as being 25 stone. These things are always subjective, aren't they? I'm not sure that's really huge. I spoke to a barrister called Daniel Barnett about this, and some of you may know, and he told me that he represented a few years ago the UK's heaviest man in a very similar claim, which failed. And I think Daniel said that at that stage he weighed in excess of 30 stone, and they were unable to get him out of his property, physically unable to get him out in order to attend the tribunal hearing. In the back of my mind, I'm sure he told me that it was necessary to arrange for the tribunal to go around to the claimant's house in order to obtain his evidence. So in that kind of context, Mr. Kaltoff was a bit of a lightweight, and indeed, as I mentioned, he wasn't of the view that he was disabled. But he gave evidence during the course of his clearly what had happened was that he had been dismissed by his employers, and he alleged that the dismissal related to his size, and one of the considerations for the Danish court was whether his obesity was to be regarded as a disability, because clearly if he'd been dismissed as a consequence of a disability, he would have a claim. And he gave evidence that while he didn't regard himself as being disabled, his size had prevented him from doing certain aspects of his job, or made it more difficult for him to do them, but it had not prevented him from carrying out his job successfully for 14 years. What the European Court decided in that case was that while obesity cannot be regarded as being not a disability, the relevant considerations that employers should be taking into account was back to this issue of what were the implications of the medical condition of the obesity. Did it have substantial negative long-term impacts upon the claimant or not? So I think the learning that we take from that is that we can't be as confident as a few years ago, as we used to be a few years ago, in dismissing obesity and the assumption that nobody will be able to bring a disability claim arising out of obesity. And also, I think realistically, we've got to take a pragmatic view about this and factor in that many people who suffer significant levels of obesity also suffer from related conditions, like, for example, diabetes, which are much more likely to be regarded as a disability within the UK system. And consequently, I think I would advise employers that they need to be much more cautious in dealing with obese employees and claimants in relation to disability discrimination claims. One of the things that does also occur to me in passing about this is that I think obesity is particularly interesting within this concept of definition of disability, because it's a condition that can be relatively quickly improved. So I don't know whether that means that it's maybe more like, it's more similar to the question we were discussing, that I was considering earlier about the intermittent illness. So those are just a few examples of the way in which the law has been developing recently in relation to this kind of key concept of definition of disability. I've spent a little bit of time on this because I find that it is a concept that cuts across all the different types of disability claims, and it's also something that crops up every single disability claim that I get involved in, I have to consider whether or not the claimant's disabled. So it is of key significance. One of the other concepts that I wanted to talk about in brief or less detail really is this issue of knowledge of a disability. This is relevant to employers because usually in the context of a reasonable adjustments claim, an employer is not under an obligation to provide reasonable adjustments until they are aware that a particular employee is disabled. So what I found is that this issue of date of knowledge of the disability can become quite significant in many cases. And I wanted to highlight a couple of cases which relate to the use of occupational health reports and the level of reliance that employers can put on them. While I've mentioned this issue of occupational health reports, I'd like to say that in my experience, it's worth obtaining, as a minimum, reasonable quality occupational health reports, and ideally the best reports you can get, because if you find that there's ever any tribunal litigation which involves this issue of date of knowledge, and you end up in a situation where you're trying to prove your date of knowledge based upon something that's contained in an occupational health report, in my experience, it's much better to be trying to make that argument before the tribunal with a reasonable or better quality professional report than one that isn't quite so good quality. A few years ago, I acted for a client in the Carlisle Tribunal, a respondent business, where date of knowledge was relevant to a claim for reasonable adjustments. Effectively, the claimant in that case was saying that the business should have been on knowledge of the existence of his disability for a longer period than the business was arguing. And the business case was that they had provided the claimant with reasonable adjustments from the date that they understood he was a disabled person, and they relied on an occupational health report as being the first time, as highlighting the first occasion on which they thought that the claimant was disabled for the purpose of the legislation, and they argued, or we argued, that that defined the date of knowledge. And unfortunately, the report that we had was an extremely poor quality report, which had been prepared with rather, or it was quite clear that there hadn't been a lot of thought or effort put into the preparation, and was based upon a telephone call between the person that prepared the report and the claimant. And what happened actually was that at the tribunal, although I thought that technically we had quite a good point to make on the state of knowledge issue, we got absolutely hammered by the employment judge, who's quite a forthright character, who was very critical of the quality of the occupational health report, and essentially said that because it was such a poor quality report that we couldn't be reasonably allowed to rely upon it as defining date of knowledge. So just based on that experience, I'd suggest to you that it's worth considering whether the occupational health reports that you obtain are as good as they could be. The first case that's mentioned here is a Gallup versus Newport City Council case. The reason I've referred to it as Gallup 2 is that this case was first heard in 2013 and has come back before the tribunal last year for a second crack. So what we learned actually out of both the Gallup decisions and the I think it's pronounced Donnellian and Liberata case is that there are circumstances where the employer can be able to rely upon occupational health reports as being the document or the point at which they're aware of the existence of a disability. You may have read the Gallup case, and and if not, you've no doubt heard of it. What had happened there was Mr. Gallup had been absent from work with stress and depression. And there were a series of occupational health reports over a period of time which suggested that he was not disabled, despite the impairment going on for quite a long period of time. The reports, and I suspect that they probably came from a similar source to the reports in the case that I just mentioned in Carlisle, didn't give particularly detailed reasons for their conclusion, and the council did not challenge those reports or seek any clarification or expansion of the information in the report, although they did ultimately dismiss Mr. Gallup based on the strength of the reports. The Employment Tribunal decided he was disabled, and the issue was whether the date of knowledge, the key issue became the date of knowledge argument. What was decided by the court was that when considering evidence from occupational health or other medical advisors regarding an employee's medical condition, employers should not simply rubber stamp that medical report. So a reasonable employer would not, in the view of the tribunal, divorce itself from or abrogate responsibility for looking at the factual circumstances of a particular employee. So I guess what that means is that it's not okay to simply rely completely and in isolation upon particularly a questionable or brief or ill-researched occupational health report. And in the Gallup case, it was concluded that the council had failed to form its own judgment about whether he was disabled or not. And so I think that's the key point, that there is an obligation upon the respondent to form their own judgment, and that probably ties into my experience in Carlisle. The Donnellian case was another case involving medical or occupational health reports, a more complicated set of circumstances. But interestingly, in that case, the Employment Appeal Tribunal decided that they applied the Gallup judgment and decided that the relevant test was whether or not the employer had formed its own view, but decided that on the facts in that particular case, the employer did form its own view, and that it had made reasonable use of that evidence. So what we learn from those cases is that this issue of reliance upon occupational health it does provide a possible defence for employers, provided that reliance forms part of a process where the employer is forming their own view. What is less likely to be successful in a tribunal is where nobody within the employing organisation forms their own view and simply relies upon particularly poor quality occupational health reports. So I'd advise you not to do that if that's something that crops up very often in your organisation. And the Gallup number 2 decision, when it came back to the EAT last year, essentially held that this approach was the correct one to take. So that's the significance of those 3 cases. I mentioned earlier this question of reasonable adjustments and the duty to provide reasonable adjustments, and suggested that this was something which is a large part of many employment lawyers' practices. I'm sure this is something that many experienced practitioners come across very often, and no doubt you'll be familiar with this yourself, and you'll appreciate that this arises out of, in the UK, obligations that are created by Section 20 of the Equality Act. Essentially, just by way of a recap, this provides that employers are under an obligation to provide reasonable adjustments to people who are disabled from the point at which the employer is aware of the disability. So a couple of cases that have cropped up recently on this. The G4S case is interesting because it related to a worker an employee who was disabled and was unable to carry on working in the role that he had carried out prior to his injury, and was moved by the respondent into a different, less well-paid role. And what was the live issue in that particular case was whether it would have been a reasonable adjustment to provide the claimant with additional payment above the pay grade for the role that he was carrying out, to reflect the fact that he'd been moved into it as a consequence of his disability. And it was held by the EAT that could be a reasonable adjustment. Obviously, they looked at the facts of that particular case and noted that they were dealing with a large respondent with substantial resources, etc. So if you come across a scenario where somebody is having to change role as a consequence of a disability, do not assume that there will be no obligation to consider ring fencing their or red circling, sometimes people refer to it, protecting their pay after a transfer, because that's certainly something which has been said to be an issue which could be regarded as a reasonable adjustment. The Griffiths case was one, actually, a scenario which crops up reasonably often in the public sector, which was relating to absence management procedures or attendance policies. They were described as the DWP, in this case, attendance policy, where what had happened was that the claimant had been given a written warning under the policy for 2 short spells of disability-related absence, followed by a long spell of non-disability-related absence. And she argued that her disability-related absences should be disregarded for the purpose of the attendance policy, and that should be offered to her as a reasonable adjustment. The Court of Appeal, it went through the tribunal, the Employment Appeal Tribunal, and onto the Court of Appeal, and ultimately it was held that in scenarios where an employee's disability leads to a level of absence which is a non-disabled person was unlikely to have, if the attendance management policy penalises the disabled person as a consequence of that enhanced level of absence, what is happening there is that the policy puts the disabled employee at a substantial disadvantage, and that what should happen is that an employer should consider whether it would be a reasonable adjustment to change that policy in that particular case in order to ensure that that disabled employee was not prejudiced relative to a non-disabled employee. So clearly this is something which will be considered by the court as being a suitable area for a reasonable adjustment. And it's clear that where a disabled person has disability-related absences which trigger the application of this type of policy, the duty to make reasonable adjustments will normally be engaged on the part of the employer. What's more difficult to predict in advance, of course, is the extent to which the adjustments would be reasonable. So I think what an employer would need to do in those circumstances is look at the medical, look at the disability, and look at the detriment that that disability creates for the disabled person relative to an able-bodied person. And what the employer should be doing is considering whether an adjustment should be made to compensate, or what level of adjustment is necessary to compensate the disabled employee, to put them back on a level playing field with a non-disabled employee. So that's one of the key takeaway points that I found in my experience of dealing with reasonable adjustment cases, and it's particularly an area where many of the public sector clients that I've acted for fall down quite badly, because what they tend to have is a kind of very predetermined tariff of what adjustments will be made to the normal operation of their policies for disabled people. So it may be that they get 3 extra days tolerance or something in the attendance management. And what you will find, if that scenario gets in front of a tribunal, as an employment judge will say, well, that's not the correct way to approach this. What you have to do is to look at the facts of the case and the nature of the disability and consider whether the adjustment compensates that particular claimant with that particular disability. So that's the key point that really needs to be borne in mind in relation to reasonable adjustments issues. The final point that I wanted to consider, which is something that's really blown up very recently, is this question or concept of competing protected characteristics. I'm sure that you'll know that protected characteristics are kind of legal shorthand for the types of essentially the types of protection which is afforded to employees within the workplace under the various pieces of discrimination legislation. So it will be sexuality, gender, age, discrimination. Those are the protected characteristics. So what's meant by this concept of competing protected characteristics is a situation where you may get a number of people, all of whom have a protected characteristic, and there may be that you're put in an invidious situation where you have to make a choice about who is benefited more than the other person. Probably best explained by the reference here to this case of Pawley versus First Bus. Mr. Pawley is a disabled rights campaigner, disabled wheelchair user himself. I have it in the back of my mind somewhere that this all took place in Wetherby in Yorkshire. I might be wrong about that, but what happened in this particular case was that Mr. Pawley was waiting for the bus to arrive. The bus was of a type which offered accommodation for his wheelchair. It turned up and it was so full that there was a mother with a pram in the wheelchair enclosure. Mr. Pawley asked the driver to ask her to move. The driver did ask her to move and she refused. And the key point in the claim, Mr. Pawley then brought a claim alleging that he had not been provided with a reasonable adjustment, and the reasonable adjustment that should have been offered to him by the bus company was that they should have made passengers move. It went all the way to the Supreme Court, and actually the final outcome of the decision was that although Mr. Pawley's claim succeeded, it succeeded on the facts because the court took the view that in that particular case it wasn't enough for the driver simply to say to the female with a pushchair, will you move please? And at the moment she said no, then simply say to Mr. Pawley, well, you know, I've done my best, that's it. And what the court highlighted was that the obligation to provide reasonable adjustments went beyond simply requesting a passenger to move and then taking no further action if they refuse, and that the response of the driver should depend upon the circumstances, so that if he felt that the refusal was unreasonable, then he should go further than that and take steps to encourage compliance by the passenger. So I think what this identifies to us all is that we're going to see more of these type of cases where there is competition between people who have different protected characteristics, and that what the court is going to expect us to do, or expect businesses to do, is to apply this reasonableness approach. And I think that's the way that we should be thinking about this moving forward. I note the time, and I'm due to deliver this in to a finish at 1 o'clock, which we're now at. So I'm going to draw this to a conclusion at this point with an apology that I've skipped over much of the detail of many of these cases. What I will do, I'm sure you can find them and research them online if it's something that you want to follow up in detail, but I will write this presentation up as some form of an article. It'll be made available either through the gunnercooke website or on LinkedIn, so that you'll be able to get further information there. And as I said earlier, there will be a recording of the presentation sent out to all attendees in any event. So I hope that has been of some interest and assistance to you, and I'm very grateful for your attendance. Thanks.